So let me introduce myself. I'm Gary Crane, and that's the back of my head that you see there on the screen. Oh, no. Anyway, better get out of the way of the camera. It's good to be here with you. When the mayor asked me to do this, I was thinking, how do you make something like this interesting? And the only two ways that you could possibly do it is the same way you do it at church. You either feed them or you get out early, right? You promise you'll get out early. And so maybe, I don't know if we can do both of those, but we've done one, we've accomplished one.
In progress.
Yep. Hang on just a second. I've got to turn. There we go.
Then on here.
Okay. Okay. And then
You're on mute there,
right.
so you should be good.
I want to be so.
Maybe later.
Thanks for the slipper rules.
Then if you want to expand it, both for me. Then you're ready to share.
I'm going to share.
I was just doing your screen. And if you go through. Yeah, there you go.
Got it. Can I get rid of that? Yeah, I do. Just a second here. Sorry, this is technology and I don't get paid to be a technologist. Or to be an expert in the area, so, okay, slideshow, there we go. Okay. All right. So I thought the way we'd start, land use is never really interesting. And in this room, we have probably more collective knowledge of land use than probably the legislature as a whole has, to be real honest with you. And we've got some that have been here for 30 years, Mayor Little and Donnie, and Jeff has been here a lot of years, and both Jeffs have been here a lot of years. Eric, you've been through the grinder too, Mayor. We put you through the grinder for at least one term and you're headed for another one. So, and we appreciate our planning commissioners who collectively, I think you've had probably close to 30, 40 years of experience. So it's hard to figure out exactly what you need, but the legislature says you need 4 hours of training a year. And so we're going to count this. We're going to count this 3 hours as 3 hours towards your training. Because it's not only legal training, but we're also going to be talking about master plan and zoning ordinance and a lot of that information. So what I tried to figure out is, sure, I belong to a group called the Utah Land Use Institute, which we started about maybe 30 years ago, and maybe longer than that. I can't remember. But they're a group that are actually involved in training around the state. And actually paid by the state now to train, and they put out this manual, which is called Ground Rules Handbook for Land Use Legislation. Some of you have it, but this is the updated version, and so I want to make sure we update you and get you. Do we have enough to go around?
Yeah.
Good. Good. Okay, that sounds good. But it is very informative. It's very, very plain English. It's not, there's no Latin for the attorneys. But it'll give you a fair idea of land use. So if you begin reading this evening on page 1, I'm kidding, of course. What I did was I looked at how we could reduce that down even further. And there was a distillation of 48 slides that they put together. And so I thought 48 divided by about an hour is what we got with you. That doesn't work either, right? And so finally I decided to put together just 10 slides. 10 slides that will give you a fair idea or overview of land use. It'll give you a land use roadmap, which I think is something that we can all use and remember. We need to remember. And then I thought I'd spend half of my time talking about that and the other half talking about something that came up recently. Something that was in the paper today, I think, at least I got a note that was in the paper today, something that's been in the paper in the past. Doesn't involve Morgan, but it involves one of your cities a little bit further up the canyon. It involves Heber City and the Heber City Temple. If you remember that the Heber City Temple right now is involved in litigation, 4 individuals who've sued, and this is a land use lawsuit. Just to tell you how expensive things can be, that's probably going to cost hundreds of thousands of dollars to litigate, is what it's probably going to cost. But what they've done so far is they have challenged a decision. And I'm not going to tell you what kind of decision because you're going to be the decision maker on that one. I didn't look up very many of the facts because I didn't want to look up very many of the facts, and I wanted to change them on you so that you can actually look at what the Wasatch County commissioners are looking at, maybe through certain windows, and then give me an indication of how they ought to decide, how the court ought to decide on this. So it's gone through the district court, and when it went through the district court, the challengers lost, the plaintiffs lost. And then it is now in the Supreme Court. And what the lower court judge did was they pretty much gutted all of the arguments of the plaintiff in the case. They threw them out. They said they're irrelevant or they're not valid. But what they did do, what the judge did do, was he imposed an injunction on the LDS Church, which stopped them from progressing forward with the construction of the building. That's not always a problem, but some of you have been here when we have had issues come up in the planning commission. For example, prescriptive rights, right? We had a prescriptive easement in one of your planning commission meetings that existed on somebody's property. And the response from the planning commission was, well, we can't look at something that doesn't exist. And so we went ahead and we approved the subdivision with an easement along the back of this particular subdivision. And a lot of you will remember it. And when we approved that easement, it was a certain size. Long story short, the property owner determined that the easement was much wider than that. And so we ended up in litigation for 4 years. The city wasn't directly involved in it, but we were indirectly involved. But I'm just showing you that stalling a decision because of information you don't have at this time is not always a bad thing. But stalling a decision just to delay something is a bad thing. That's not a good thing. You can table something for the purpose of specific purposes. And the mayor wanted me to bring this to not only the planning commission's attention, but also the council. But you can table something if you need additional information. But when you table something, and our legislative specialist over here, Ray, will tell you when you table something, you really need to table it for a reason. And you need to lay out those reasons so that staff has a good idea of what you want, so that you're not just unreasonably delaying the project. One of the questions I have on this temple situation is whether or not it's just an unreasonable delay of the situation, because the LDS Church has agreed that they would accept full responsibility and liability, which, by the way, we have all of our developers do as well. If they proceed forward and there's a question on something, and we proceed forward anyway and approve it, because it looks like it's legally sound, they can accept responsibility for whatever they build and have to take down or tear down afterwards. But the church is so confident that they would post a bond to indicate that they would do that. But they want them to post a bond also on the other side, indicating that if we fail, if the plaintiff fails, that you have to pay the church what it would cost them to delay the project a year, which is about what it would delay that project up there. And so it'll be interesting to see if the Supreme Court says, no, we're going to let the church accept the responsibility, or whether or not they will actually require them to post a bond. To give you an idea of the difference in cost, and that's a temple, right? It's a big building. It's a very expensive building, but a subdivision costs. If you delay, for every day that we delay a subdivision approval, you have to seriously think about it. Have we got our questions answered or have we not? If we don't, take the time to table it, move to the next meeting, and get your answers. You're not expected to make a decision without information. But if you do have all of the answers and the only reason you want to delay it is to, just for the sake of delaying it, you don't have any information for staff to collect, whatever, it's costly. In the case of the church, they estimate about $11 million over 12 months. And so they're requesting that the plaintiffs post a $17 million bond. So that's quite a large bond. Anyway, the reason I tell you that is because at the end of this, and I've already burned up some of the time, so I'm going to clip through this really fast. I'm going to ask you to look at the building of the temple and this application through about 3 different lenses. Okay, a land use lens, land use regulation lens, and there's a difference in the code between a land use regulation and a land use decision. Land use regulation is a legislative act. And legislative acts have to comply with this, they have to comply with that, and they have to comply with that. And they have to comply with that before you can get that. Local ordinances. And so I'm going to ask you to look through it with that lens. Then the second lens I'm going to ask you to look at it through is an administrative lens. Now, once the legislature has passed, I gotta remember to tap ahead here. Let's see, where am I? Oh, let's see, I just do this. That's easy. Okay.
You don't make questions right now.
Sure, yeah, questions all the way through. You're good.
We're going to go to slide just a second.
Yeah.
Oh, I'm sorry. So this has been something that's been on my mind for quite some time. You remember this, Gary? Ray remembers this. We had a home over here that somebody wanted to buy and they wanted to put it in, and I can't, for lack of a better term, I have a halfway house, would have been maybe described as a halfway house. You know, it was a class of individuals that would be living here. I remember that night we had that public hearing here. It was standing room only and everybody. But after the fact, when we talked about it, basically you told us because they were a protected class, they fell under either that federal or that state statute. Is that correct?
Yeah.
So we essentially that night we were all sitting here talking about it. Didn't really matter because we were still subject to that state statute, right? Or federal statute.
All of these things count. And
Yeah.
that federal statute governed group homes. And
So
you
it wouldn't
really have,
Wouldn't have mattered what we came
but
up
no
with.
matter what you came up with, if you came up with something denying a group home in a residential area, it would have been a violation of federal statute. That's the reason I'm going to tell you up front that is kind of the ace in the hole for the temple. And that is that there's a federal law called RLUIPA. And that law says that, you know what, when it comes to religious institutions, that you cannot use your local ordinances or even your county ordinances or your state statutes to encumber religious institutions. And so you'll notice in our zoning ordinance, and this is part of what you're going to learn tonight, and that is that in our zoning ordinances, religious institutions come under what they call community uses, and they're permitted in just about every zone. And so it's very interesting that this lawsuit has progressed to the point it has progressed to. Let me go really quickly through your analysis of a legislative act. You've got the planning commission. Planning commission are the quote unquote experts. Let's go to page or second one. You're the citizen planners and you're the professionals. You're the experts. And literally you're meant to learn enough to be able to qualify as experts because you're going to give the city council the information they need in order to make decision on ordinance changes, on zone changes, on master plan changes, on things that we call legislative acts. And oh, good. Legislative acts are general plan, annexation, zoning ordinances, zoning maps, development agreements, some of them. If they act like a zone change in a development agreement, which in a Moab case they did by increasing the density, by development agreement, then the courts consider them to be legislative acts and they need to be approved by the planning commission, by the city council, by going through that legislative process. And then planned unit developments. You've got your overlay zone, right? The one overlay zone that you've got in the city right now. That's a legislative act. That's not an administrative act. On the other side of the board, you got your administrative acts, subdivisions, conditional uses. This is where I think that they've gone with the temple. I think maybe it's a conditional use. I don't know. I don't know for sure. But you've got these standard or these items, site plan approvals, building permits are also administrative acts, and variances are administrative acts. And also determinations of non-conforming use, they're all administrative acts. And what is the difference between a legislative and administrative act? Well, a bunch. Okay, but let me tell you let's go back down again. A legislative standard, and I'm just going to tell you, it's anything, any reason upon which reasonable minds can differ. That's the legislative standard for making a legislative act. So the city council has really broad discretion when it comes to legislative acts. When it comes to zoning decisions that the city council has before them, they must have a rational basis, and it can't be illegal, and it can't be arbitrary, and it can't be capricious, but still it is anything upon which reasonable minds can differ. That's a really easy standard. There's never been a case in the state of Utah where anybody has ever won challenging a zone change, just so you know. City council can pretty much make any decision they want relative to zone change. Planning commissions, you can make a determination just about to advise the city council any direction on a zone change. But the safest direction is one that is based on the general plan. That's number one. Second, you've looked at the utilities and whether or not the city has the utilities, adequate utilities to be able to provide. And then also transportation access is another one that you look at in a zoning decision. But I'm going to tell you, zoning decisions are pretty easy to make and they're always upheld. The second one, the administrative acts are not quite as easy. Administrative acts, they have to be supported by substantial evidence on the record. Let's talk about the record for a minute. You know, a lot of times we make easy zoning decisions and easy administrative decisions, such as a subdivision approval or a conditional use approval, and there's not a word said as to why you made the decision. I mean, we had a lot of discussion during the course of making the decision, but at the very end, when the decision's made like that. Very helpful if you try and condense at the end of your proceeding, or when the motion is made, they always call for a second, they call for discussion on the motion. And I've always said that it would be very helpful for the body that's making the motion to, at that point, just put their reasons in the record, to put them in the record, so that we don't have to go hunting for them. Now, can you go hunting for them? The courts have said, yes, you can. So I can go through the minutes of a meeting and I can try and pull out what you said and what you've said and what you've said, and try and justify the decision you made. But it's really helpful if you put those reasons on the record at the end. So difference between a legislative act is you can essentially approve a legislative decision for any reason based on a master plan, based on good sound zoning reason, but it doesn't need to be really seriously researched or anything else.
You talk about zoning, you talk about approval. You could also go there, you could also disallow it,
Yes.
correct?
Yeah.
So in zoning, it could go either way.
Yes.
It's not that you have to approve somebody with a zone request. You can deny the zone request.
Can.
So
Yeah.
it goes both ways.
And on your overlay zone, that's the reason we created it as a zoning decision or a legislative decision. And that is so that the council does have the opportunity to see that decision, because the council sees all legislative decisions. However, as a result of legislative acts over the last 2 years, council does not see subdivision applications anymore. And you remember all the subdivision applications that we've seen in the past. The council used to go to the council will review it, and they don't anymore. And so I feel bad because a lot of these people that come up and speak in public comment think that the council can do something. Once the zoning is set, the only thing the council can do is apply the law to the only thing that can be done by the city, and it can't be done by the council, is to apply the law to the facts. And it's the planning commission that does that. They do a preliminary approval. But the final approval, they've even taken that out of the hands of the planning commission and the city council. And they've said the final approval has to be made by anybody but the planning commission and the city council. And so the city council has appointed staff to essentially make that final approval. However, staff is relying heavily on whatever the planning commission comes up with when it comes to preliminary approval. That's probably what you're going to see most commonly. Every once in a while, you're going to see a conditional use. A conditional use is a use in every zone. You've got two different types of uses. You got permitted and you got conditional. Permitted or allowed as of right. That temple is probably allowed as of right on the site. That it's in fact, it sounds like it was zoned residential is what it was zoned. So it is probably allowed as of right there. And you remember we had that pile of books? You got federal law and you got state law that protect certain uses and say they must be permitted uses. Otherwise, the city council makes a determination of what should be permitted and what should be conditional. And we have a table in the code that show both conditional and permitted uses. Conditional uses are uses that might fit into the zone if the negative impacts of that use can be mitigated somehow. Go ahead.
Question, so if the federal overrides everything and it allows a religious institution to build anywhere, why is there even how can it even be contested?
So
Because lawyers in courts.
I know the lawyer involved and I know exactly right.
Because lawyers
The-
in courts, that's the reason.
It's in it, that's why I'm thinking it's probably not a legislative act that they're fighting over, because that would have been dead from the very beginning. It would have been dead before it went to the Supreme Court. It's an administrative act. What they're doing is they're arguing, and what I get from the whole thing is the lighting of the temple. They're arguing that you can't mitigate the negative impacts of the temple on that neighborhood lighting wise, that you can't do that because the church wants to light it at night and they don't want it lit at night. However, can that be mitigated? In other words, can that be eliminated? Yes. And from everything I understand, the church has agreed to turn off the lights at night, which is kind of interesting. And it's a dark sky policy that they have, but I don't think it's an ordinance that they have, because it would be very clear if it was an ordinance. The difference between legislative acts and administrative acts are, once the legislature or the city council has made a decision to impose an ordinance, that ordinance must be met. It's mandatory. It's even mandatory on the city. There was a case in Salt Lake where Hermes was coming in and wanted to put a great big Shopko in, is what they wanted to do. And the city wanted that so bad because the sales tax on it was so great. And doggone, the streets were just too narrow. They didn't allow for commercial businesses on 31-foot streets. And there was a 31-foot street that allowed access. And the city said, okay, we're gonna go ahead. We'll sign off on that. We want that department store. And what happened? The neighbors challenged it. They challenged it, and neighbors can bring a challenge, but the challenge has to be real and it has to diminish the value of their property somewhat. Which there aren't very many things that will actually do that, or very many ways that is accomplished. And so Hermes the city ended up in losing that case. It was the county, actually, Salt Lake County, that lost that case and lost the department store because they were accurate. They didn't apply the law to the ordinance, and the city has to abide by its own law. It can't breach its own law. Vested rights is another term that you're going to hear, because we've come across that a couple of times in the planning commission where somebody has filed an application, then we've gone and we've changed the ordinance afterwards. And now, in fact, we've got some old subdivisions that are being developed, that were developed under the old ordinance. and we got new subdivisions that would be required to do something new. A vested right means that there's a time in the process of an application where everything is frozen, where the ordinance is frozen and where even the impact fee that you charge is frozen. You can vary that, however, if the actual costs are greater, but for the most part, everything's frozen. With the streets, all of that's frozen. It's called a vested right. And in Utah, we have the earliest vesting requirement of any state. And it's the date that a completed application is filed. So from the date a completed application is filed, that person can build according to whatever the code says they can build to. And so,
So
yeah,
is that the same thing as saying it's grandfathered?
that's similar, very similar concept. You bet. Yeah, that's a good analogy.
Is there a timeline on that?
There is on subdivisions and there is on zone changes. So zone change, zone change is just the opposite.
Yeah.
Because you file for a zone change and if you're denied, you can't apply for another year.
Right.
And so you'd lose that vesting doesn't count. That vesting would not count. However, if you got a subdivision and you don't do anything on it, you got preliminary subdivision for a year. I think it's a year that we still have in our ordinance. They're trying to get rid of that up at the legislature right now. That's probably one of the 9 bills you said have already been pre-filed. But that would be the restrictions, whatever restrictions we put on it, the council puts on it is what would apply. So vested rights are important. What if you got something that is zinging through, an application that is zinging through that is just not what you meant to approve, and you want to change that so bad your teeth ache because you're going, uh-oh, we never intended that use for that particular area. A new use, and they do pop up from time to time. All of a sudden we had vaping shops all over the place in Layton when I was city attorney Layton. And it was urgent that we somehow control where these are, that there be a similar circle around them that there is around tobacco uses or alcohol uses or whatever else. Well, there's 2 ways that you can stop something from happening. And it's rare that we do it, but there's 2 ways. One would be that if there's a countervailing, compelling public reason for stopping it, you can say, stop right here. There's a safety issue here. And we deemed vaping to be a safety issue because the shops were definitely a health concern. And the number that we're coming in unregulated. And until we got a good license ordinance in place, it was bad for this many to go in. So we stopped everything. That's one of the rare cases that I can remember. The other situation is where you see a need to change the code, but nobody's filed an application yet. Okay. You have 160 days
For temporary.
for the temporary. From the date that I'm
180.
looking to my planner here because
I think
he deals with on the ground, 180. So it's about half a year. But you can stop everything. You have to make some official act, either through and really it can be the planning commission that says, hey, we found something, we want to stop everything. So we're going to start moving forward with a change in the ordinance. And this is the ordinance we're going to change. And any application that then comes in is stopped for 180 days. And if you change the ordinance after that, guess what? The application is subject to that change in the ordinance. That's the second way that you can prevent an ordinance from moving forward that you're wanting to change and somebody's trying to come in under the wire. That happens.
So I'm gonna ask you a crazy question. So let's say you mentioned a vaping shop, okay? Maybe an SOB, sexually oriented business. Is it wise to actually put that in a certain zone? I mean, do you want a zone for that somewhere where you don't want it? Does that make sense? Or can they just build that anywhere they want there where there's a commercial zone?
Well, it's interesting because I did a mediation on a St. George vape shop. And St. George, the way they handled it was they put them in the places that were the rarest place that somebody would want to build. Like in the middle of industrial zones. That's kind of the way the city's handled it. But can you eliminate them altogether? Yes, you can. You could eliminate them altogether. If you didn't want that kind of use in your city, there are some that are protected. SOBs are one where they're very controversial and there's a whole bunch of case law on SOBs and on where they can be placed and how many can be placed and that type of thing because of the First Amendment concerns that they have regarding dancers and
Okay.
that type of thing. And so SOBs are a little different, but for the most part, can you prohibit a use in the city? Yeah, you could. But be careful, okay? That's a legislative act that you would put into place. And the interesting thing about it is in your ordinance, you have, of course, permitted uses and conditional uses. And in your ordinance, it says that if it's not specifically identified in the ordinance, you can't bring it in. And yet you can bring these things in under a conditional use. You can either make them permitted or conditional. In Sandy, the courts determined that when it comes to administrative acts, that we're always going to defer to the property owner. And so in Sandy City, they determined that multiple residential units within a single unit was reasonably within their definition of residential units. And it was challenged by the city. The city said, no, we didn't mean for that to happen. So you got to be careful what you put into your ordinance because the ordinance is always going to be read in favor of the property owner. Always going to be read in favor of the property owner. And if there's a question, if the plain language is not clear, it's going to be read in favor of the property owner. We're running out of time, but let's talk about public clamor for a second. Administrative decisions are subject to usually one hearing. Subdivision approvals are a single hearing. Conditional uses no longer have a hearing. It's pretty much your decision, planning commission on a conditional use. There are no hearings before the council anymore for administrative acts of any sort. I can't think of any administrative act that is left on the books where there's a public hearing. However, the legislative acts, you're going to get a lot of people that can come in and talk about legislative acts. That's where they have the ability to do that or to give public input. Public clamor is a term that the courts used. You like my picture? I thought that was good. Yeah. Plaid shirt. Anyway. Yeah. It's definitely people whose land is located next to something that is coming in dense, all right, density, higher density. But public clamor is something in a Davis County court and ultimately the Supreme Court made a determination is not acceptable evidence in an administrative hearing. Remember I told you that the evidence in administrative hearing has to be substantial evidence based on the evidence that you have coming in before you. It has to be substantial evidence. Guess what the court said substantial evidence is? They said more than a mere scintilla, a little bit, but less than a preponderance, which is about 51%. So somewhere between 1% and 51% is the standard that you use to make an administrative decision as to whether or not it complies with the law or not. And in many of these cases, you're going to hear a lot of the same arguments, especially when it comes to densities and subdivision. And that is, it's going to lower the value of my property. It's going to kill children on the streets. There's not enough school capacity for kids. Is that a valid reason?
No.
No. Is safety a valid reason?
Yes.
Yeah, sure it is. But what the court said is, hey, you had realtors in there. The city had, the developer had realtors in there who were experts in the area of property values. And they said the value wasn't going down. And you had your police chief stand and say, we haven't had any accidents on this type of street in this area. And this area has essentially is accident free. And there's plenty of capacity on the street. Your engineer has said that. And so public clamor is essentially public information that's good to listen to, but in the end, it's not supported by any evidence. That's the problem. And I mean, it's always good to listen to. Councils and you at church on Sunday have to listen to it, all right? Planning commissions are not supposed to have ex parte communications. It's easy for you because you can say, you know what, as a planning commission member, I'm not allowed to talk to you about this because the application is pending. But city council people are a little bit different. They're a little bit different. Now, do they listen to you? That's another issue, right? They probably just go to the next planning commissioner. But the city council was elected to listen. And so you will listen. And even though your answer will be the same on administrative decisions, that is, guess what? We don't make it. We can look at the law now, see how we want to change it, but we don't make those decisions. We don't make those administrative decisions. We make the laws that govern those administrative decisions, but we don't make those administrative decisions anymore. So if you see something that needs to change as a planning commission member or as a city council member, let's get on it. Let's look at changing that ordinance because you're going to be bound by that ordinance when it comes before you. You're not going to be able to say, oh, that street, yeah, we can make it 1 foot smaller so we can get a Hermes in there, or we can, we can increase the density, but only by one home. You don't have that authority. The decision's already been made for you. And as planning commissioners, you are the defender of the ordinance, essentially is what you are. Let me just go and see where we're at here. Okay, so plain language and no, we're good. Right there. When you, this is the last thing I'm going to talk about. I think it's the last thing. Let me just look. Yeah.
Interpretation, due process.
Yeah, we're good.
Okay.
Well, because I want you to make a decision on the temple. All right. In just a second, we'll talk about that. And this is a whole class in and of itself. It's a whole instruction in and of itself. And that is, how much can you ask for from the developer? I mean, can you ask them to put in gold pipes? Can you ask them to put in marble sidewalk? Can you ask them to put in, okay, just how about a 1 foot wider sidewalk than what the code says? Or can you ask them to put in more landscaping or a park in the corner of a city? One of my favorite examples was there was when they did go to the city council for subdivision approval, there was a city council person in one particular city that got sued over this, where one of the accesses from the subdivision accessed onto a UDOT highway. And UDOT said, no way, we're not going to let you do that. And so the developer came back and the city goes, well, there are 2 other accesses. I think we're all right. And one of the city council people said, well, hey, since you're not putting in that access, how about putting in a park on about 2 or 3 of your lots? And made that a requirement. And the developer challenged it. And it was deemed to be an illegal taking. That's a whole separate area of the law. How much do we ask a developer for? I remember in Layton, we had Gordon Avenue that goes, you've probably traveled on it, goes all the way down. And you've got the subdivision on the south side that is old home subdivision, essentially 55 and older. And they had, the developer had come in, he developed, and in a really bad moment for that developer, he agreed to grant them all the land for that roadway. And it's a 110 foot wide roadway, all the way down to where, well, close to where the freeway starts. And I looked at it when it came through and I thought, you know what? The developer has about 4 years to challenge this after we get finished imposing this requirement. And so I had the engineer go back in and say, here is your proportional share, developer. And what he does is he does his calculation that so much traffic is going out there from his subdivision, he should pay for that part of the road. But as far as the rest of it goes, that's for the city. That's 110 foot right of way. All they require is a 31 foot right or 32 foot right of way in order to be able to make their subdivision work. And we're making them put in 110 feet. Can you imagine the lawsuit a little later when the developer wakes up and says, "Oh, the city took all that property from me and made me put in asphalt and curb and gutter." It was millions of dollars is what it would have been. So you got to be careful what you ask for. Can you stretch it a little bit? Jake is really good at, planners are good at stretching it. I can tell you that. Planning commissions are good at stretching it. And unfortunately, city councils don't see that anymore. So the city council person that required park, you'd never see that happen anymore because
Gary, one recent example on the subdivision, Valley Vista, we asked for a 10-foot trail easement, they gave it to us, and then we asked for a 20-foot trail easement and they gave it to us. And it was just asking. It wasn't required by law. It was just, negotiation. And we offer to put in the trail when we get funding and grants and things like that. But
a lot of times it's an exchange like that, city.
yeah,
But if it's an exchange of an approval on an application, it becomes a requirement. And we had one situation where we have a secondary water company and we provide a lot of our water through that secondary water company. But a lot of those individuals in the water company were requiring reinforced concrete pipe, 36-inch, whenever they had to pipe a ditch. And you remember, we went through that and that was an excessive exaction that would have been subject to the city having to pay for part of that back because they don't need reinforced concrete when it's just piping a ditch. Under the roads you do, but you don't need it over here. And so by the city requiring that, even though it's a secondary water company, we required them to go to the secondary water company to get water. And by doing that, we imposed upon ourselves a requirement or a restriction on what we can ask for. And so, okay.
So
Mayor.
they can't go back on that if we say ask for a wider sidewalk, whatever they agree to it.
No, the way that we do that as attorneys is I want to make sure that they understand what we're asking them for. And so we usually do a development agreement along with that. So not only have you got the ordinance that requires, just your standard sidewalk and stuff, but I always like to have, if we're doing some additional things, making some additional deals, a development agreement is the best way to do that. And that is finally approved by the council. Development agreements are still approved by the council because they're contracts with the city is what they are. So that's another way of being able to require design standards. You can't require anymore as a planning commission on ordinary subdivisions, but you can on your overlay zone, and you can in commercial. And so we put together a contract that is a contract between us and the developer where we both understand each other. And in the case of Jake's situation, the developer agreed by contract, by agreement, that he would do this. It's more than a handshake. It's in writing that he agrees to it.
and it was added to the plat, and so that's where it's adopted it's official and it's recorded at the county. And so I think anytime there is an exchange, then it needs to be in some kind of legal recorded format, whether a development agreement or a plat or construction documents.
Gary, let's say you have a piece of ground that's zoned commercial. Okay, this can maybe get a little close to home here. All right. Developer comes, the property owner comes to you and says, the developer wants to buy my property and put houses in here. We don't see this ever being used as commercial for who knows how long, but the city says it's a perfect place for a commercial development at some point in time. We want to keep it commercial. Do they have a right then to deny? And, so there's a zone change application because somebody wants to build homes on it. Can the planning commission say, no, we're not going to make that zone change because we feel as a city, this is still a very valid place for potential commercial development in the future?
That's why the planning commission is paid the big bucks.
I mean, are they getting,
Because yes, the answer is
Say no.
yes, if there are valid reasons for wanting to keep that. And is that a valid reason that, yeah, we do it all over the city. You say that, we want lower density over here, higher density over here. We want our commercial uses to be here. We want our historic uses to be there. And does it matter? We've got a business park out there that we're still waiting for people to come into, but we know eventually will.
Yeah.
And so, yes, that's what you do, and that's the reason you do it, is you're expected to look down the road and say, now, if you keep it agricultural forever and refuse to rezone it, how about that? Can you do that? No, you have to do the master planning in order to support your decision not to rezone it to residential, right? If you don't have your master plan in place and current, or you don't have good valid reasons for keeping it commercial or commercial and not residential, then it's probably going to be difficult, not to make that decision. But quite frankly, I told you how easy it is to make legislative decisions. So the developer is going to have to do a lot of work on the planning commission, the council, to convince them to change the zoning to residential, because you don't have to do it. You just don't have to do it. That's where you've got the most flexibility is annexation. You can ask them to put in gold-plated sidewalks with annexation. But on a rezone, you've got plenty of flexibility there. When it comes to the administrative decisions, you lose your flexibility. You're just enforcing an ordinance. And if your ordinances aren't up to date, and by the way, there's a handout on updating your ordinance in there that's really, really good, that I encourage the planning commission to take a look at. It's a schedule for updating the ordinance, and I'll give one quickly. Mayor, good things.
Annexation, I think you told us in the past that that's when we have the most ability to say no
True.
on annexation. Even if we don't want, for whatever reasons, we have the most ability to say no and not succumb to the developer.
You had pizza before you came to
And
me.
you just flat tell them no.
Got an upset stomach, and you decide, now I'm gonna deny every application, an annexation application. You could do that.
Okay.
It doesn't go to the planning commission first, just so you know, it goes to the council.
I'll talk to tabling something for just a minute. You brought, talk about that very first. Well, let me mention that in my years of being involved, sometimes you get an issue coming before you that you don't quite understand, don't quite know a lot about yet, or you fail to do your research, you had a tough 2 weeks. If you don't feel comfortable about what that is, don't have the knowledge of it, please consider tabling it for 1 month. You're not going to be in trouble for tabling it for a month, as long as you do your research between the two meetings to answer your questions. If you legitimately don't know about something or feel uneasy, let me recommend you consider tabling it. But do your work in between.
You can table how long?
Till the next regular scheduled meeting.
Yeah, it's good to table it to a date certain, so we don't have to re-advertise. That's
Till the next regular scheduled meeting. Don't be afraid of doing that. The other piece I'd like to talk to is voting. For a long, long time, I remember back in the day, we used to have 2-3 split votes all the time. And that's okay. You don't need to have a unanimous vote. If you, for some reason, have a feeling that something should or shouldn't happen and the motion is not your direction, don't be a sheep. Don't follow and vote just because that's what the motion is. Lynn Mickelson and I for years, we're on it together, good friends. There's a lot of times we'd vote against each other. When we walked out the door, we were still good friends. We shake hands and talk. So voting against someone should not enter any disagreement between the two of you. You can have a friendly discussion, or you can have a mindset that's not the same as your other member, and that's okay. I think we need to get that in our mind. It's okay to not vote the same as everybody else if you have a logical reason.
Yeah, and a lawful reason.
Yeah, lawful reason. If it's due with the ordinance, dealing with the ordinance.
And we'll talk, the next training we'll have probably, which will only be an hour long, will be on conflicts of interest, because they're entitled to an unbiased group to look at their applications. And if you're biased one direction or another, we'll talk about what constitutes bias and how that's developed and what reasons you should not vote on something probably the next time. Okay, really quickly. The temple, if it was a zoning decision from agricultural to residential and the council approved it, would it be in the Supreme Court today? Can you deny that? Can you deny the temple the opportunity to locate your Wasatch County commissioners and you're looking at a application by the LDS Church to rezone a parcel of property from agricultural to residential for the purpose of putting a temple on it? Can you turn that down? No, we talked about,
Is it a protected class?
yes, religion. We talked about RLUIPA. We talked about, First Amendment. All of those things come into play. But even more so than that, if you see that in the greater good of the community, and it's usually only the minority that are seen on these issues. I mean, we saw that in a couple of different situations we've had here in Morgan County, where a minority has literally held a project up for a long period of time. And where the majority are all going, they don't come to the meetings. The people who agree with the project don't come to the meetings. Should you not listen to the minority? No, they might have some good points. There might not be enough water. There may be a problem with the roads. There may be, you always listen to them, but in planning decisions, in legislative decisions, can you make a decision against, well, say the mayor takes a vote from everybody. Okay. How many want this property to be zoned to residential so they can build a temple? Is that a fair way to make a zoning decision? No. But if you reason it out, it's consistent with the master plan, you have adequate utilities, you have adequate access. Is there a reason to deny that zoning? It wouldn't be in the court today, right? It would not be at the Supreme Court. Okay, how about an administrative decision? What if you have an ordinance in there that says that we believe in dark skies and you should do everything you can to make sure the skies stay dark in Heber City? And you challenge the approval of the temple, the site plan and everything else, based on the fact that this temple is going to light the sky up at nights. There's an ordinance that says we ought to try and keep dark skies as much as we can.
But they agreed to turn the lights off, so there goes that.
They agreed to mitigate that, right? So good point. So is there substantial evidence that they're not complying with the ordinance? No.
It's the difference between should and shall. That's the question there.
There's a lot of shoulds in the ordinance, more than there should be. But the shalls, you have to make sure you comply with. You have to make sure. My guess, and thumbs up or thumbs down, how do you think the Supreme Court, the lower court tossed it out. How do you think the Supreme Court is going to make a determination if it's an administrative decision like that? And the LDS churches agreed to turn their lights off at night.
So that's their biggest complaint.
That's the lights. Yeah.
So if they make an agreement to shut them off, then they're held accountable to do that.
Yeah, it would be a condition on their approval. And
Even though there was already
the approval would probably, or could be, well, the approval was given with that agreement to turn them off. Is my understanding, is what it said in the paper today. They agreed to turn them off before. Yeah, I don't think the LDS Church would let it go all the way to the Supreme Court. Here's another little tip. And then I got to turn it over to Jake because I've eaten in his time, but everybody was eating in mine. And so it's, but this is the reason for looking down the road. It's when we had an inkling in Layton that there was going to be a temple. And I looked through our zoning ordinance, went through it very carefully. And I looked at lighting, I looked at height, and automatically found that height, it would be prohibited in residential zone because of height. And so before the temple even came into being, planning commission recommended a change in the height in a residential zone. And so when the temple came in with its application, everything that they needed in order to put it there was already in place. And I'm not saying you do that for every building that, you know, that you can't second guess what's coming in. But you can look at subdivisions, you can look at densities, you can look at all of those things. And the planning commission ought to continually be updating its ordinance, looking at the ordinance. If you don't look at your ordinance, and Jake's great at this because he brings something to you every single month, but you ought to be checking your current ordinance too, because in the handout I gave you, Brent Bateman makes the statement. He says, how many people think that their ordinance is out of date? And there were a few that didn't put their hands up. He says, you're all out of date. There's no question you're. I went through our conditional use requirements the other day, just in preparation for this. They're out of date. They're out of date. Every year the legislature changes things. And then on top of that, conditions change, densities change, people build, you know, you ought to continually be looking at that. And that's the reason they've taken you out of the decision-making process, is to give you time to look at the ordinance and how it ought to be changed, because a lot of things you could prevent from happening and by just changing the ordinance. Questions? Any other questions?
Did Weber City or Wasatch County, did they have something in their ordinance to addressing dark skies?
Yes.
That it was there then?
Yeah, it was there, but it was a should. And so, but the church complied with that,
Right.
my understanding. And so really, I think that's the reason the lower court threw it out. And they said, the term was they gutted the lower court gutted their arguments. And I happen to know the attorney on this thing because I had 2 cases with him in Layton. And he likes to take these cases that are out on the fringe and they go on forever. And his big thing is this being recorded? Anyway. His big thing is delay until you choke something to death. And so if the church can get a bond in place, or if the church can get, to have them post a bond, I think that's fair. Or if the church accepts responsibility and continue forward with the construction, that's fair too. And I think that's probably in the future, if we come across a situation like this, that's probably what we would allow too. We'd have the developer waive, if it was some little legal requirement like a prescriptive right or something of that nature, we still let the development go forward because time is money for a lot of those developments. Anyway, thank you very much. I think my last slide.
Oh, I just switched.
Oh, did you? Okay.
Is that okay?
It says applause, but I go ahead. And you're welcome anytime to call me with questions. I'd rather have the questions in advance of something happening than after the fact and anything at all. So
I'm gonna jump in. So we have, Bruce, until 1:45, is that right? Okay, so we have about 35 minutes. And I just want to give you an update on the general plan. So our current general plan was adopted 2024, March. The planning commission spent more than 2 years on it. Very thorough process. City council also spent a lot of time on it. Well, the changes that we're looking at are probably 15 to 20% of the whole. Somewhere in that range, very minor. So I want to hit those. A lot of this will be a review, if you've participated in the process in the last year. I'm just gonna discuss, parks and recreation, trails, transportation, downtown, and future land use. And the Morgan City General Plan is a 15 to 20-year vision. But remember, this is not all at once. This is not just this year, next year, the next few years. It's gonna serve as a guide for our community aspirations, our goals, our economy. conservation, infrastructure, whatever. Those are some of the main things to keep in mind. Good. So Parks and Recreation, looking at, this is in our draft document. The real basis of the whole plan is the Weaver River. We have this beautiful gem, the Weaver River coming from the city. And the big idea that came out of our workshop was the Emerald Necklace. Boston had the original plan of the Emerald Necklace in terms of the plan. And so the trail on the Weaver River connects it all. Our existing Riverside Park. And then what I have here is PCR as partner community recreation. So the Wilkinson Complex at the high school, and then also the county fairgrounds. Those are not Morgan City Park, but they're our partners in recreation. And then we have the future park, which is the Fish Pond Park. The city owns the land. I've already got some grant money to look at it, but not all of it. And then also what we're saying is somewhere over here as Morgan grows in the southwest to have a park in this area. It doesn't necessarily mean on any specific land because the town does not own land yet, but we're saying we need a park in this area. We definitely need a park in North Morgan. Those are the two big areas to really be looking at for future land. City owns this property up here, but that's water conservation. That's where the water comes from. So no specific plans there. Also, as part of our public process, the community definitely wants a recreation center. They may not necessarily want to pay for it, but they want a recreation center. And so it's in the plan, it's aspirational, but it's not necessarily a guaranteed promise from the city to the public that's saying we're looking at it. They want pools, they want courts, they want facilities, but the pool is the big thing that the public would like to see in that. So that's kind of the big overall vision. Improve the two existing parks, downtown parks, so we'll get to the plaza and the train park, and then the cemeteries with the C there. And then also, if the dairy property got built in a park there, and that's an if, and that's how the general plan works is, we're not saying we want a park on your land, give it to us. We're saying, you have a big property, if that area was developed in the future, then we'd like to see a park in there, part of it. If that remains as a dairy forever, then great, that's a dairy. But if it gets developed, then we'd like to see a park. And the same happens down here in the southwest. And then I'm gonna go through some of the concepts here. So looking at North Morgan, as part of this process, we asked, what does North Morgan need? What's reasonable? And this was one of the concepts that came up that was pretty popular. 3-acre park. We get a parking lot with 62 stalls, some kind of multi purpose. Could be soccer, lacrosse, any kind of field sport. 4 pickleball courts. Pickleball is still growing in popularity. Playground, kind of a little miscellaneous area, trail around the perimeter, and then a few pavilions and bathrooms. So as you're talking to people or keep an eye out there, think where can we get a 3-acre park or a 3-acre piece of property? And the big thing in terms of park development, first just get the land and then work on funding to get a park. That's how it happens. Is really get the land is the key part. So this is just a concept for the Fish Pond Park, some kind of pond, tying to the river, parking lot, maybe a bridge across the river. This area, this is the stormwater basin for Tractor Supply, but it also could be a dog park if we wanted to make an agreement with them. Still function as a stormwater pond, but actually be a dog park as well. This is an example of a cool little fish pond park in Idaho Falls by the Snake River. And the same idea of bringing the water in from the river and then going back out. But it's kind of an idea there. But I really could see this happening over the next 5 years in the city.
I'm new here, but I have a question.
Yeah.
For the fish pond park, what is the intended use for it? Like, do people kayak? Do they stand up paddleboard on it, or is it just walk around and?
Walking, fishing, I think paddling would be great on it. Definitely multi-purpose.
Okay.
Ty, do you want to add to that?
Just that the main use is fishing. So DNR is a partner and would dictate the engineering on the water depth and all of that. So fish can winter in there, and then they've also agreed to maintain, so they plant fish and maintain it as a fishery.
And the city already own that.
Yeah, the city owns
Okay.
this piece right here.
Okay.
7 acres, 10?
5, I think.
5 acres, okay. I think it's enough to do it. Also, part of this process, the public would really like to have more recreation access on Weaver River. There's very little places that you just wanna go put your feet in the river or do it safely. I know there's the check dams upstream. People like to wade through or paddle through the river, and those are challenges, those check dams, they serve a function. But that's something as well. And there's a lot of really good examples out there of cities that have built kayak parks. That could be something that could be really fun. Ogden has that. So this is Riverside Park. We just looked at how could it be improved, maybe upgrading the skate park, some upgrades to the baseball, and I know that you have a partner that's helping with that right now. We could look at maybe adding some pickleball courts in this grass area up here. So going 8 there. Just looking at how to kind of fresh it up. Maybe newer playgrounds and things like that. But it's already a great park. I mean, it's the one big park in town. So here's a render of the plaza under construction. It's getting close. I talked to the landscape contractor today. He's looking at rock material plants and getting really close. It's gonna have almost most of this that's in the rendering. The city already owns the band, the bandstand. This is blue concrete. It's not ice skating. That I think was just poured. The turf will go in when it's ready. They've been digging for the footings for the shade sail. They keep hitting utilities, so they're having to move that. The parking is all in now. Of course, you've probably seen that. They've plumbed the gas for the fire pit. And so that'll be on a timer so the public can push it for 15 minutes or whatever that time they'll turn on. And so this is gonna really generate, I think, a lot of interest in the downtown. The neighboring landowners are already submitting applications and looking at upgrading. This is really a catalyst to completely change and improve all of commercial street area.
Does it make any sense to put a big rendering of that over near where that's happening, so people know what's going on?
Yeah, I think we could do that. I think that'd be a lot of
That's a
fun.
really good
I get asked questions all the time.
You do? Yeah.
And,
I think it would be really easy. If the buildings would let us put it on the building, that'd be easy. Freestanding, we just want to keep it out of the way of the contractors.
Yeah.
Is probably the big part. And maybe we could do it on Commercial Street if one of the vendors would let us put some renderings just on the window, kind of tape them on the inside, and that would be super easy. Do that. And it is gonna have bistro lighting here in the alley. We'll have some lights around. There'll be plugs so that food trucks or other things can happen. I mean, it's meant to be kind of a multi-purpose outdoor space. And one thing in downtown planning is if we can have more than 250 activities a year, then it would be very successful. And activities could be a juggler or a chalk festival, a garage band from kids in Morgan that think they're cool. And, you know, it could be anything that just brings somebody downtown. And that's because that way hey, it's Friday night, there's gonna be something down in the plaza, let's just go down there. So, and we're still working on the name. We'll be getting back on that. Okay, train park. So the idea, we have the caboose, and the idea is just to make it a little bit more historic. And I'll walk you through the concept design, but a big challenge as we're looking at this is just the land is owned by the railroad, and they're very difficult to deal with. And so we're kind of working through that. We'll have to see how the railroad works with us, but.
So we have an easement. We recorded an easement,
And does it let us do?
landscaping.
improvements? Landscaping? Okay,
Mhm.
this looks like landscaping to me.
Mhm.
Well,
We told them it was for a park,
Okay.
so it's,
Okay.
but-
Maybe he was scaring me a little too much.
he might not know that we recorded the easement.
Okay, well, good, I feel a lot better with that. So here's the visitor center, which is the old train depot. So you walk across the street from, I think Deb's is right over there. And then some sidewalks here in white. There's the caboose, some fun signage out. Maybe get people to take Instagram photos, some seating. This is the grass area, some picnics here. And then this is kind of a raised platform for viewing. It'd be really close to the train if you want a close up train, right? It's already very loud, but a nice hangout place. And then maybe a food truck spot, and then come down here, some additional gravel parking. I mean, it's like it's already there, so some nice upgrades and improving it and giving people something to do on this part of Commercial Street.
On that rendering there, the green grass right there, is that the grass that exists right now?
Yes, that's the grass that exists. There were some dead trees there.
There's some trees there.
So,
So as you continue down, down that way,
yeah,
along that grass, is there anything that we could do down that way? It'd be nice to put a few little picnic tables down there, because people like to grab ice cream, but there's nowhere, they just end up sitting on the grass. It'd be
yeah.
kind of cool to have a little.
I don't see the easement allow for that.
You're talking
See one of our plans, we have a sidewalk trail on the opposite side of.
It's on that little slope,
that side.
that little grassy slope.
Sure. I guess we'll have to look, I like that idea, we've talked about a trail there, I mean, we have that whole frontage across of all of Commercial Street, if we could just walk across the street and sit on it'd have to be, I mean, it's a hillside, so it'd have to basically be like a little retaining wall cut in, but that could be a nice little seating cove.
So there's gonna be a fence separating the park from the track?
There is, it
Yeah,
stops
yeah.
somewhere, there's a chain link fence that stops in here, and the plan is to continue that down. Just, not as a visual barrier, but as just a safety barrier. For kids.
Where's everybody in the park their car?
The plaza.
Oh,
Okay, any question on parks? We kind of went through, I'm gonna go back to the master plan. We don't have any renderings of the rec center, but we didn't really want to get into that because we didn't necessarily want to over commit. And we did ask in our survey, we asked the public, you know, how are they willing to support it? And there's a little bit of a mixed bag. Some are willing to, you know, pay a fee when they go, membership, or okay with taxes going up, and others are not, but it has to be funded from somewhere. Some communities, like in Camas, they have a partnership with the school district in terms of sharing facilities. Skyview in Smithfield has that. There's a rec center there where they share that. But we heard from the school district that they weren't too in favor of that at the time we asked the question. But this would be a fantastic location for some kind of rec center being across from the high school.
Go back there already.
Also.
I do, I do, I guess they did large a little.
What's that?
Increases.
All right. Okay, let's go on to trails.
Dean House. So Dean House.
Okay, so this is the trail plan. As I mentioned, the Weaver River is the backbone of the trail system. And the blue ones are paved, separated pathway, kind of like the trail at the Riverside Park asphalt path. separated, maybe at a park, maybe next to the road. Also paved, of course, concrete down on Young Street, which is just built this year. That's a good example of separated pathway. I mean, it's a sidewalk, but it's wider and separated. Green is bike lanes. On a few locations, and then yellow are soft surface trails. Could be, mountain biking, hiking, walking, gravel. So really focusing those up in the foothills and around, down at East Canyon Creek there, tying in over to the county fairgrounds, maybe something up, towards the end. And then this is that easement that mentioned that we got the 20-foot easement, this line right here that connects over to the shooting range. So at this point, it looks like a lot of trails, which it is, but it's also a 20-year plan. And I don't think we'll get all of it, but if we get half or a quarter, then we're a lot further than we were before. And there is a significant amount of state grant money for trails once you have an adopted trail plan. So, any questions on trails and active transportation? Oh, I do want to mention, pedestrian crossings is a priority. So our original plan has, what are called hawk lights. That's where you push a button and it starts flashing. Kaysville Movie Theater has one. There's a few other places around Wasatch Front have them. And so definitely on State Street and Industrial, maybe a couple other locations, that's gonna be, pending what UDOT will do. And then certainly across I-15. And right now, the UDOT is doing a study, starting at this intersection here on the north side, and then going out until the edge of town, looking at all of State Street. But the focus really is this corridor here on State, and pedestrian safety is a big part of that. So we have talked about it'd be nice to, there could be a pedestrian bridge over, a tunnel or something, because it is, of course, very dangerous to cross the freeway. But I don't know that there's any specific answers. We do have this crossing on this part of town under the freeway, but there's not good access back, and also it's an open crossing across the railroad. So if there was a lot of people there, maybe the railroad would bring up issues.
UDOT put that over the freeway into their study.
Oh, they did,
Yeah.
okay, that's great. So that's being looked at in some kind of pedestrian bridge over the freeway in this area. So, and then also there's, down by the Young Street Bridge location as well. Okay, transportation. All the existing roads are this kind of aqua color. Those are major collectors. And then the yellow are all the local roads. And then proposed roads or future roads are the dashed red lines. This one is something that the engineer suggested that we add. And also this here, I think that's part of the recent plans. And the idea on the future roads is that when an area is developed, then we want a road in that area. Okay, the plan doesn't say you own that private property and the city says you gotta go build that road now. But it does mean if the dairy was built or developed, then we would want some roads. And it can still shift during that planning and design phase. It's not exact. But it does give the city leverage to say we want this connection. These ones is part of the Creekside Meadow. Those are actually gonna be, and we had this as an adopted plan when they came in for the subdivision, and they did have to add these roads and comply because we had transportation in place. I think that was a win for the city to get us those connections that are in progress. Well, planning right now. Well, actually, they started construction. Is it almost done?
Yeah.
Yeah, almost done.
The roads are.
Yeah, the roads are. So coming in here. And as we're doing this update, now is a really good time to take a look at the map with some fresh eyes and be like, oh, we need a connection here or there. And it may not be happen anytime soon, but it's a good time to add it to the map. In particular, we looked at Island Road. It'd be nice to have those additional connections. It's very narrow, it's busy, there's a lot of safety concerns on Island Road. If there were any kind of emergencies, how would we have a second access to Island Road? And that's where having one or two additional bridges access would be really important.
What's the road that comes out of that subdivision in North Morgan? Does that go under the freeway or down?
That one?
Yeah.
Yeah. That might be.
That's through that subdivision.
Oh, yeah,
Ends
it
up
doesn't
through-
go through, it doesn't go under the freeway, it's to a frontage road, and it looks like you forgot to put the frontage
Yeah, the
road.
frontage road isn't on there, is it?
Oh, Frontage Road runs one here.
Mhm.
Yeah,
Yeah, so we need to add that one.
so let's add that frontage road.
And then we also have this should be on there as well as part of the Grace annexation. And we could even show that going underneath there.
Mountain Fair.
Yes,
Yeah.
it's not fully improved, it's an old county and a half road.
What is the other one up there?
This one? The engineer added that one, is that
So
is that in Valley Vista now?
No.
No, he's saying that if this property up here were developed, we want this connection. And a lot of times that's how it is with the new road is if a property is developed, then we would like a connection
So,
there.
Jake, is that the road going down to the sewer lagoons? You just call it the Freeze property, yeah, okay. Okay, there is a road there now, it's just a gravel dirt road,
Yeah.
of course. So you're showing, eventually that's showing an extension across the river and hooking on over to, yeah.
Yes. Hypothetical and that could be 10, 20
Time
years
started
down.
raining, sure.
At some point, we'll definitely stop because nobody wants to live next to the sewer lagoon. Some kind of buffer at that point, but we're not even close there now. Any thoughts? Eric, I know this is your territory down here, so you disagree, tell us, it's okay, this is discussion.
Well, I just sat here telling Laura Ann, I says, if you look at it, yes, it's great to have the plan, but again, this is all hypothetical on. There's a lot of things that's gotta happen in order to get
Oh, yeah.
that kind of a bridge across.
Yeah, the school district, right?
Yeah, the school district owns that bridge where you just pointing, coming across by the sewer lagoons. There'd have to be a lot of things that would fall into place in order to get that road there.
And I
Yeah.
think,
I can recognize the thing of, hey, yeah, we need to get another access out of the island road, we understand that. I'm just saying, again, everybody's gotta remember, this is a hypothetical deal, cause that would have, in order for that to happen, there'd have to be a lot of things that would have to fall into place.
You also have to remember, I'm not doing another bridge.
Yeah, there'd be like, I'm like looking at that going, you gotta cross like probably, 8 properties or so, and it'd have to line up.
This one in here is maybe a little bit easier. just
Yeah,
so-
maybe right there by the substation, but again,
And that
but
would
then
be
again, you'd have to
additional
have that other
density
side.
developed.
You'd have to have the other side of Clark's.
Yeah,
And-
yeah, and that's probably the big part of
Yeah.
that one, is the other side.
we always talk about, we need more connectivity with the city, and if you don't have a plan, you can't have.
Yeah.
And so, as, you have to have a plan, hey, we want roads around here, and so when you do finally have,
I won't be-
like Mayor and I always talk, we'll be dead before a lot of this will happen, but, you have to have it. If you don't, how can you push that? This is exactly what Gary's training was about. This is if, you don't have code or you don't have a plan, and you really ask. We were looking through staff and everything, okay, where do we want connectivity? Like in North Morgan, that particular road we were talking about there has a lot to do with infrastructure, more than it does the road. Because we need to build up our infrastructure up there, and normally infrastructure is in a road, so, you know, some of these might not make sense as far as people driving on it, but it could eventually. With a lot of creativity.
I was gonna ask about bike paths. What color did you say they are? We have a lot of kids that ride those e-bikes that are so.
The blue or the separated bike path. So,
That's not more of the e-bike thing, that's recreational.
it could, well, e-bike has become a big range. And I just was talking with the police officer last night. If it can't be pedaled, they call it a motorcycle, and if they don't have a license to drive a motorcycle, they're getting tickets. And if they go up to 40, 50 miles an hour, just a couple of plug-in.
Yeah.
But,
14-year-old going 60 miles an hour.
I think it's a matter of speed. And on the Jordan River Trail now in Salt Lake, the miles per hour was 15. And I'm hearing that's what cities are doing, setting it at 15, that's a good range. We could go up or down from that. So maybe that's the question is, if you're gonna ride an e-bike on it, just keep it at 15 or whatever. Is, you safe by
I guess
the
I'm more concerned about kids on e-bikes than on the adults.
Yeah, I agree, I agree.
A lot of kids.
Yeah, I had my neighbor actually got killed a month ago. He moved out, passed that stop sign, came up with his bike, and the driver it was just right there on 35 mile an hour. I'm thinking of it, all the ones that get about hour. Yeah, and he wasn't.
For 16.
There's a lot of.
It was 14.
14.
That street where you go.
That's the other road under.
Hitching post. It's just by the hitching post. Under the freeway to the hitching post.
And by this, we're saying we need to be looking at that. We only have so many places to cross 84, and so each one really needs to be studied.
Ray, that'll have to be there for when you come from the post. And we're gonna do that.
Sure, it's so wide.
State. On state.
Yeah, so like the one that's down on I-15.
Oh, you're talking about
Did they
example?
stick the red caps in to leave a message?
Oh, yeah. I don't know the number of that one, but that's the idea. There's a few of those. There's one in Ogden, kind of by the Hinckley Airport.
Yeah. So we're talking about something like that over a freeway?
It's in the discussion with the UDOT.
You gotta give permission.
They come with millions of dollars for payments for
Yeah.
what they cost, so.
And then we can take red paper cups and put welcome home, elder somebody. on
Yeah.
it.
Okay, any questions on transportation? Real quick, part of the downtown plan, this kind of purple magenta area, walkable, mixed use, having as much connections as we can. By mixed use, we're saying, residential above or behind, retail, commercial, just really create a hub of activity that's already happening. And we wanted to have a very traditional Main Street theme. In Planning Commission, we've talked a lot about, is it historic like a movie set, which you can't touch or do anything with? Or is it have a nice historic feel and keep the nice historic buildings, but allow for progress? And it feels, that's where the Planning Commission is going is let's have a nice traditional Main Street feel, but we don't want to lock somebody at 1929 and you can't touch your building even though it's falling apart. So, but some important parts of this are a street connection coming off of Industrial over to Commercial Street, and then also hypothetically through the 7-Eleven gas station. You'll even see there's the pump right there. That would be a great location as well. And I even throwing out this idea of closing Commercial Street if we got these street connections. This is your most dangerous intersection in the whole city. And cars stack up and just sit there, what you have, you'll see all the problems. But this could really open up some good opportunity in that area. The plaza, the alley, which is nearly complete, this new street, which is developed up to this point, would continue out when this landowner decides to ever develop, even though he hasn't talked to anybody in town. And as we shift over to State Street, a little bit more commercial focus, a little bit more auto oriented, still some mixed uses, but keep going there. Crosswalk on industrial, and then is this 450 east? 400 east, and then also down when we get next to the river where the trail would continue as well. So those three locations is what we're kind of requesting from you to have those pedestrian lights. Now, if a full traffic light comes in, then that's okay too. No, it's not wanted, but that's a different issue. Vehicles are a different issue than wanting pedestrian crossing. And then the idea here of river-oriented commercial, in Logan, there's the Riverwoods development. They have the nice Elements restaurant right there on the river with patio. And the idea is really have some nice retail commercial development on the river, take advantage of that. And some other ideas are a trail on the north side of Commercial Street, and then a little bit of a pipe dream, but maybe a pedestrian bridge over to the co-op building, school historic building. Could it function as a kind of a wedding reception kind of a place? People look at for that. So, and maybe if we get some kind of pedestrian bridge, maybe that is fine and work together with that. Time?
Yeah, we're close.
Okay.
We're already at 6:45.
Okay. Okay, these are the renderings. We'll send this out in email. And then the last thing is the future land use. So study this out a little bit. This is changed a little bit. The biggest change is, I'll just say that what we're talking about in low density residential is, well, low density residential is the same. And then medium density residential, single family only, going from medium sized lots to small lots and not attached housing. That's the big change from before.
So you're gonna email this out to us?
Yeah.
That's what I want to see.
Okay. So thank you. And you, planning commission, we'll be talking about it next week on Tuesday. And then council, you'll see this next year. Right?
Alright, so city council, you'll take your mic up to the podium for the next meeting.
Oh, yeah, I want to see that.
It's not. Yes, city sort of. Some sugar.
Well.
Assuming we'll leave up there.
Yes. You know. You guys were so quiet. I get my own. You're welcome.
Who's sitting here? What does that one say?
Yeah.
Wardell?
Yeah.
There you go, Merry Christmas.
Well, thanks. Right.
Jeffrey, throw that on his, look at our whole thing so full of stuff now.
Yeah, what?
Jeffrey,
Who's that?
nobody, because Dave Alexander's gone, so everyone shipped it down.
Oh, okay. So I need to shift only this way.
Yeah. That's the mayor. So Tony went from there to
Here.
here, yeah. I've got all Tony's stuff.
Yes, that's it. Get right out of Jeff's. Anyway.
Oh, yeah. Sign in.
Okay.
Yeah. First off.
Yeah.
Yeah.
Ray,
Oh.
I'm coming for you.
Appreciate it. Let's do that. Sorry, I'm signed in. Where do you want to?
Move you down that way.
Tony's lot. I want to even change things up.
I said, I'm on the wrong side of the mayor.
Since you packing.
I don't sit on the left.
You're right. You're left-handed. So. Mine gets you your advantage. Where's the RDA? That's for. Farewell.
It's like the old days. You sit here while you. It's good to be in.
It's not staying, I'll see not on there. Okay.
If you don't want what.
Yeah, he always has something to say.
Always. But it turned off. You can. You're, you have some power. Right?
Thank you.
Yeah, I'm like,
Okay. One of the oldest.
Where is mine? Okay. I finally found my agenda. I would like to welcome everybody to our redevelopment agency of Morgan City. And I will entertain a motion to approve the meeting's agenda.
So moved, Mayor.
Seconded.
Any other discussion or corrections? If not, all in favor? Any opposed? Hey, Janet, that's unanimous. Okay, let's go to the consent agenda. Item 2, A, redevelopment agency of Morgan meeting minutes of June 24th, 2025.
Mayor, I will make a motion that we approve of the redevelopment agency minutes of Morgan on June 24th, 2025.
I'll second that motion.
Any other discussion? Okay, all in favor?
Aye.
Any opposed?
Aye.
Hey, Janet, that's unanimous. Let's move to the active agenda, and I apologize, we're a little bit behind.
Well, we can make that time.
We can make it up fast, yeah. Review action, a resolution adopting and approving an agreement entitled Land Purchase and Settlement Agreement between Morgan City Redevelopment Agency, and Old First National Building. And that's been changed from Old First National Bank LLC to Old First National Building. Resolution R 2528. Hi, or Gary, do you want to move us along on that?
So, as you know, we've talked about this, is the last piece of property for the plaza, the alleyway and plaza, last 428 feet, 428 square feet. And we just kept the same, honored the same price that we started with when the whole thing was appraised. Just right behind the Old National Building, and we came to terms and got it signed. So this is the last piece of property. And then just for the RDA's sake, the RDA's purchased all of these individual properties, and we're gonna get all of them combined into one property, and the city will buy back the property from the RDA. Yeah, and they'll get recorded just as city property, so. This is the last of the property purchases, and then I don't remember if it says, but when we approve the purchase, then it's gonna be more after the closing and the other fees, you know, that the title company tax on than just the amount listed in the. So just to make you aware, it's gonna be a little bit more than that.
With just those fees.
Yeah, just the documents and title report and stuff like that we've added to it, so.
Have any discussion, or Gary, you have anything to add?
I think I's done a really good job of negotiating this with the banker, and I think it's a good agreement.
And then as part of the settlement, we're gonna dedicate a parking stall to the owner of the bank building, and that's more for city council than the RDA. This is just for the purchase of the property, and then in city council, then there's more of the terms of what we've agreed to in the settlement. But that's why it's called and settlement agreement, so.
So does this kind of clean everything up there, Ty?
Yep.
Okay,
So can I ask one more question?
yes.
So I remember discussing this a while ago. He's talking about how those property lines are all askew over there as far as, has that all been pretty much resolved as well? And
Yeah, as far as in the back, all of the ones that we've bought have all been resurveyed. And we've purchased them with the property descriptions as surveyed. So everything that we own is surveyed and has legal descriptions, and the new parcel that we have will all be correct.
okay,
There's still some lateral lines like between the Vallis and Red Rock. But those lines that need settled, that they need to figure out what they're doing, doesn't affect our property. Right, so like the line between the two buildings goes all the way to the alley, but the alley is surveyed and is correct. There's no challenge on the new the portion that the city owns. So you kind of have to fix it as you go on those property lines, but ours will get brand new property descriptions.
okay.
Any more discussion?
But
I'll entertain a motion.
I'll go. Chairman Gale, I'll make a motion that we pass resolution R 25-28, a resolution adopting and approving an agreement entitled Land Purchase and Settlement Agreement between Morgan City Redevelopment Agency, and the Old First National Building LLC.
second it,
Okay. We're done with discussion? Okay. Oh, well, let's see. I need an A, huh?
Aye.
An I. Not an A, an I.
Aye.
Eric?
Yeah.
Tony?
aye.
Aye. Jeffrey?
Aye.
Okay, Janet, that's unanimous.
Thank you, Ty and Gary, for the work to get that done. Been a while.
Yeah, it has.
Thank you very much.
It's been on the burner for a while.
Mostly Gary.
We'll move on to our council meeting, if I can find my,
Adjourn this one.
okay. What's that?
We probably ought to adjourn this
Yeah.
one. Oh,
We'll adjourn this meeting. I forgot my thing, Craig.
got your gavel?
Nice.
They picked the best one ever. You guys had some wisdom by picking this one.
You don't even need to get.
Like I'm eating cookies too.
You get treats and a short one. These kids.
Nobody better leave early.
There's-
Nobody better leave early.
They will be.
Sign the roster and. Like one lieutenant.
Gotta be in,
Huh?
have to be in the, political science class.
Yeah. Huh?
We'll drive.
Like the class.
You guys need any help? Okay.
Holy smokes.
Science class.
I think we'll just walk over that table where we eat.
Oh, yeah, yeah.
Mayor, we have some students as well. Yeah, so students as well. Did you see that? Students?
Yes. You're gonna embarrass us.
Okay.
Yeah, we have a handful. We have one right now.
Well, one from.
Everything shipped out to the desert. Already turned in there. It's interesting. Okay. Oh, interesting.
Okay, welcome to our city council meeting, December 9th, 2025. I've asked, if I get this right, I've asked Jeff to give the pledge and Tony to give us a prayer.
Everybody rise and repeat the pledge. I
Pledge allegiance to the flag of the United States of America, and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all.
Our Father in heaven, as we convene at the commencement of our city council meeting this night, we wish to take this opportunity we have to express our thanks, gratitude unto thee for the many blessings that we enjoy. We're grateful, Father, for the freedoms that we have living in this country. And we're grateful for this beautiful valley in which we live, for the opportunity which we have of living here. And we're grateful for the opportunity that we have to serve and try to make our community a pleasant place to live and to reside in. We're thankful for those who live here and for their support and for their spirit of unity and volunteerism that we have in this community. And we're certainly grateful for all of these things. Father, we ask that thou might bless us as we convene this night, that as we have decisions to make concerning the city and its future, that we might be in accordance with thy will. We might always act in a fair and a just manner and do those things which would be for the benefit of our community and the people living herein. Father, we'd ask that thou might bless those who have provided these freedoms for us, continue to do so, those who have served and do serve in our own forces, that thou might protect and watch over them, as well as those who serve in other capacities of service to our communities, that thou might bless and watch over them and protect them. Again, Father, we're grateful unto thee for all which we have. We're thankful for all of our many blessings and continue blessed that thou might continue to do so. We say these things in the name of thy Son, Jesus Christ. Amen.
Amen. Thank you. Okay, has everybody had a chance to look at the meeting's agenda? And if so, no more discussion, then I will.
Mayor, I'll make a motion that we approve the meeting's agenda.
I'll second it.
Okay, we have a motion and a second to approve tonight's meeting's agenda. All in favor?
Aye.
Any opposed? Okay, Janet, that's unanimous. Let's go to the consent agenda. I had a couple of changes on my daughter's name. She's a last name Tilby. Instead of, I can't remember what it was, and I've got so much paperwork up here that I now can't find it. So if you would research that, Janet, and just change her name to Katie Tilby. That's my correction. Is there any others that?
Just a quick question, Mayor. So I noticed, are we also going to approve of the minutes of the work meeting that same night?
What was the reason? Was that? Did we approve of them last meeting?
Did we?
Seems like there was something a little bit different that we approved the work meeting, but.
Oh, because there is the work meeting attached on.
Yeah, because the work meeting is attached to our agenda tonight. I was just curious.
You mean tonight's?
There are some minutes from that attached in the packet.
Okay, so but our consent agenda says we're approving the minutes of the council meeting. Do we also need to approve of the minutes of the work session? So both of them.
Yes.
Okay.
Good catch. Too.
Is there any more discussion? Or corrections?
Mayor? I will then make a motion that we approve of the minutes of this Morgan City Council meeting on November 25th, 2025, and also of the minutes of the work session that same night, 12/9/2025. Wait a second. Yes. No.
Yeah.
Yeah, that same night, excuse me, of the work session, that same,
Yes.
the 25th, yes. And the warrants from November 22nd, 2025 to December 5th, 2025.
And I'll second that, Mayor.
Okay, do we have any more discussion? All in favor?
Aye.
Any opposed? Okay, that's unanimous, Janet. Okay, let's move, before we move on to citizen comments, we have a lot of students here. Welcome. And this is for your political science class. Okay, so just so we're fair and we're consistent, I believe you have like 30 minutes you need to stay, is that right?
It's a trick question.
Till the end.
So I think that's what I remember from the others. So what I'm saying is, thank you for being here and thank you for being, on task for your class, but I also know it's sort of boring when you're that old. So if it's your requirement at 30 minutes, then we'll just say that you're okay to be excused unless you want to stay with us, okay? But thanks for being here. We'd also like to thank everyone else. As I've vocalized many times, I love when we have public here. And I appreciate the opportunity to hear from you. I think we just have one comment. So Scott, I have your comment before us and we've all had that, so you're welcome to stand at the pulpit and state your name. Dead.
My name is Scott Jensen. I live on 700 East. And as I stated in my comments submitted, that my main concern, and that I believe of my neighbors that are here and were here that are very much concerned about this in accordance with what I said. So I won't go into a lot of detail because I've submitted the same comments to the neighborhood who are here. This is the general city plan, 134 pages of text and graphics. Now, for the general public, which includes my neighbors, reading this and understanding it is like asking someone for the first time to read the New Testament and then get experts to tell them how to properly interpret it so they can know if a particular doctrine conforms with it. That's totally unreasonable for the general public to understand that, even if they do show up to these meetings and make comments. It's up to the city and the city council to understand that. And what appears to me happened when the zone request for the Wardell property was granted by the city council unanimous vote, they were misinformed with regard to adjacent zoning, which was corrected, but the city council didn't see fit to appeal that and request a revote. They just went ahead with the original vote. So it seems, and I hope Tony doesn't mind me mentioning his name, but reading the minutes, he asked some questions of clarification on this during the meeting, and he was informed by the planning commission that according to some funny math that is called net, what is the term, net occupancy, or that they can average out
Net density.
net density, there we go, thank you. Based on net density, which is in somewhere in the text, which I haven't had anybody to identify it, where it is, so I can look at it. According to the text, adjacent properties that are single family, including the roadway, can be factored in and averaged out to reach the general city plan of medium density, 3 to 5 units per acre, allowing a 14-unit rental building to be placed in the middle of our neighborhood, like the two other Wardell projects behind Barbara here, that is doing the same thing, which is clearly incompatible with the time and place of the neighborhood, which I believe the city plan also addresses. So based on appropriate fit for the neighborhood, neglecting the density issue, it doesn't comply with this. And I believe, you know, I've requested clarification on that. And my last point is the developer no doubt has legal advisors representing them if they feel that their rights are not being granted to them. The city has Gary to represent them, but the neighborhood has no legal representation. I think there's a will to get that. And so I'm just requesting the city give us a little space to pursue that before they grant approval of the developer's plan. Anyway, appreciate that, and I'll thank you.
Thank you.
Thank you. Appreciate your comment. And I don't believe, Janet, anybody else has filled up an app to speak. Okay. So again, thank you for your comment, and this isn't the meeting that we respond to that.
I understand. That's one of the issues.
Okay.
Excuse me, let me just.
Who does the community go to for answers to questions and concerns, since the city council meeting is not the place to do that? There is no forum.
Gary?
Okay, so there were two phases to this project. The first was the zone change, and that was a legislative act, and that decision came to the city council at that time. And I think you properly related the fact that the city council passed that, which essentially vests the developer in the right to be able to proceed forward with his subdivision. Then it becomes a question of, can he meet the ordinance? And the individuals that review and are charged with enforcing the ordinance is the planning commission. And they'll look at the plan after staff has had the opportunity of reviewing, the attorney, the engineer, planner, and all we are doing and all we are allowed to do at that point, and it never comes back to the council, just so you know, the decision never comes back to the council. That was a decision made by the legislature 2 years ago. All subdivisions used to come to the council for final approval. They don't anymore. They haven't for 2 years. And then the second thing is that they don't even go to the planning commission anymore for final approval. The legislature has said that the only people that can make final approval is anybody the city council appoints other than the planning commission and the city council. They are the ones that finally approve. So what this city council has done is they have elected to have the staff who follows it all the way through, track the ordinance and make sure that the applicant meets all of the terms of the ordinance. And so at this point, that's the point we're at. We're at the point where the staff has gone through and done a check of the ordinance against what the developer has submitted. We are bound, the city is bound to follow its own ordinance. We must follow our own ordinance. And so that's what we've done, is we've gone through and we've looked at the ordinance in comparison to the plan that the developer has submitted. We've made some comments, we've made some adjustments. It'll come to the planning commission for preliminary approval. The planning commission looks at it. They check too to see that the ordinance is met. That's really all they can do. They don't have any discretion at all outside of the ordinance. And so if something needs to change in the way that the ordinance reads or the way that the requirements the ordinance imposes, then that would be a legislative act on the part of the city council. They have to go through the planning commission to the city council and you can change the ordinance. They can change the ordinance. But as far as this application goes, the zoning has been approved. The developer is vested in the zoning, and the developer at that period of time is vested in their application also for subdivision approval. In other words, the laws that are in effect at that time for subdivisions apply to this developer. And we're an early vesting state. That happens the day that the developer comes in with his application. And that application then is compared to the ordinance. If he meets the ordinance, the city has to approve the project. There is no choice that the city has other than to be sued, I guess, is the only other choice, is for the developer to say, no, I've met the ordinance and that needs to happen. We just talked about this in our prior meeting. You have a similar situation going on up in Heber right now with a certain facility where you've got an administrative decision that has been made and it has been appealed all the way up to the Supreme Court. So that's the process that would occur. But as far as this council is concerned, the legislature 2 years ago took away their opportunity to weigh in on subdivisions once the zoning is in place. So that's something that if you want to change, you're going to have to go to the legislature to have them change it. We fought that for years and they ended up putting that in place. So really the point it's at right now is it will go to the planning commission, I think the next meeting, for preliminary approval. And what the planning commission is going to do, they're going to ask staff what things were they required to do, have they met all of those requirements? And staff will at that time indicate they have or they haven't. If they haven't, planning commission will impose those requirements on them. And then staff will once the planning commission gives preliminary approval, it will go to staff. So right now it is really in staff's hands. It is with the engineer, it's with the planner. The legal issues on the plat would be my concern, but those are just the legal issues. And then Teresa, who's also staff for the city. Then it'll go to the planning commission. You'll be able to go to that meeting. It's not a public hearing. It's just a place where a public meeting where you're allowed to listen to what the planning commission, their concerns are relative to the ordinance. And then the planning commission will either approve it because it meets the ordinance, or they'll deny it because it doesn't meet the ordinance in some way. If it doesn't meet the ordinance, the developer has the opportunity of amending it until it does. But that's where we're at. And then the final approval will be made by staff, which will be the engineer, the city attorney, and the planner. And that's just the way the law reads right now. And so I hope that answers your question. So right now, if you've got comments that need to be made, I think you're getting them to the right person, which is staff. They should come out at the planning commission meeting, and the planning commission will indicate, what they're meeting and what they're not. the thing the planning commission can't do is they can't impose their own requirements. They can't change the city's requirements. They can't ignore the city's requirements. This developer is vested in those requirements right now. And so all the planning commission really does is just check to see that they're met. That's a longer explanation than you wanted, but if you wanted to, you could have come 2 hours before now and heard an even longer explanation of all of that, because we train the planning commissioners and the city council. But that's where it's at right now is with staff, with Teresa, with Jake, with Matt, and with myself. So does that answer the question? Okay.
Okay, thank you. Okay. I don't have anybody on paper to make a comment, so those that would like to stay are welcome to stay, or if you'd like to exit, you can exit at this point. Except the students, your half hour isn't up yet. Okay, let's move to the active agenda. Review action, a resolution adopting and approving an agreement entitled Land Purchase and Settlement Agreement between Morgan City Redevelopment Agency, and the Old First National Building, LLC, Resolution 2529.
That's an old one. should
It
say
says
building.
bank and it's updated to say building,
Okay.
because it's
Yeah.
not a bank
Gotcha.
anymore.
I caught it.
Yep, so this is a land purchase agreement and settlement. It's for the last piece of property that we needed for the alleyway and plaza. This is directly behind the old First National Building. It's 428 square feet. We've offered and they've accepted $16 a square foot, which is pretty much the same price we've bought all of the property back there for. As part of the settlement, in order to acquire the property, we're dedicating them one stall for as long as they own the building. So that requirement will go away if they ever sell. It won't transfer to a future owner. And then there's a map in the back that shows where that parking spot would be. So the fourth stall in from 125 North. They had asked for different parking, the prime customer parking, but we were able to settle away from that, so. I think that's all I have.
I just got one little thing on the map. There's some apartments back there and there's a couple of spots dedicated for that.
Yeah.
Is anybody ready for a motion?
Mayor, I will make a motion that we approve resolution 25-29. It's a resolution adopting and approving an agreement entitled Land Purchase and Settlement Agreement between Morgan City Redevelopment Agency, and Old First National Building, LLC.
Mayor, I'll second that motion.
Okay, do we have any other discussion? Rick?
Aye.
Tony?
Aye.
Aye. Jeffrey?
Aye.
Hey, Janet, that's unanimous. Move to item 5. Does the city council have any reports or business they'd like to bring up?
You do.
Hmm?
You do. Then that bag, yeah, that.
Yeah,
bag.
I was gonna.
Oh, just make sure you didn't forget.
No, it's gonna be climatic.
Okay.
I can't wait.
I would just say kudos and thanks to those responsible for the hometown Christmas on Saturday, the chamber and city. I thought it was well attended and
There were a
really,
lot of people.
really nice activities. A lot of people were there, so appreciate their work and their effort in hosting that every year. So, and encourage everyone to come out to it in the future. It's a lot of
And
fun.
our city employees out gathering garbage and
Yeah.
working on a Saturday and setting the stage up, taking it down, so tell them thanks. It turned out great, closing the roads and
Friday and Saturday.
shoveling horse manure and whatever else they had to do, so.
It was a good event.
Okay. Bye.
So just one update, we just received a secondary water meter grant. So on North Morgan where we have secondary water connections, but there's no meter. The state has a requirement to install meters on all those secondary connections. And so we got a grant to help us do that today, 173,000. It's a 60-40 split. So the total project's $288,000 to get secondary meters installed. So,
That's just in that district of.
yep.
That's in that old special improvement district. Is that what we're talking about?
Yeah.
That area?
Okay. Well, it's my turn. I'd like to tell a great man, thanks for all his service, all the years that he spent on the city council. And is that a happy smile?
It is. Yeah, it is a happy smile. It's been good. It's been good.
We appreciate your service and your input, and welcome at least our new one. I think she's still.
He's over there.
He's over here.
Welcome you next month. So be ready to be somewhat, not embarrassed, but
It can't happen.
so
That's the guy right there that got me into this deal over there, sitting over there. He's the one that got me into this. So
the city would like to present you a thank you.
thank you, Mayor. Appreciate it. Thank you.
Don't throw the card away. There's something in there too, but you
Okay.
know,
Give it to me.
you know how,
Yeah.
how ladies can stuff the bag, and they do such a good job that it might hide one of the most important things.
Yeah.
You should pull it out. You don't need to, it doesn't need to be packaged up.
Do it now?
Yeah.
Okay.
Yeah.
Okay.
Yeah, Merry Christmas. Birthday.
Actually, let me open that.
Yeah, why don't you present it to
Open
him?
that, I want to present it to you.
All right.
I want to get out of the picture.
First off, you get one AA battery.
Just what I wanted. That's awesome. There you go, Ty. I got a battery.
And picked out an incredible clock
Oh, that's awesome.
that says 10 years of service. Morgan City Council from 2016 to 2025 already.
Yeah,
It's gone fast.
it does. Oh.
I'm waiting for the clock. Well, we don't have a battery, so it's not on the right time, but sincerely, thank you for your service.
You know, it has been a pleasure to serve and to learn more about local government and city government and how it functions and all the things that go into running the city. It until you get here, you don't even realize what it does take to run a city. You just, and so I, like the mayor says, encourage people to get involved and find out exactly what it takes to run a city. It is not an easy task. So appreciate all that's been here, the mayor and staff and Ty and all the things that you're able to accomplish and do. So thank you.
So do you have a ratio between thank yous and criticism?
I should.
Is there one that leans more than the other?
Thank you. Always, always. Thank you.
I also like to have Gary come up. We have a card for you.
Are you leaving?
This is it.
Depending how I envision it'll happen.
I say it's not walking paper.
Oh,
It's a thank you for all you do for us. And we appreciate you, helping us. And like you mentioned earlier, we had an extensive, work meeting, training that, really will help us in the future. And so appreciate your efforts there and all you have done at the state legislature for almost as old as you are, isn't it? And representing us the best you can. And even though sometimes it feels like a losing battle, we appreciate your presence. And I think that you would, also voice the same thing as Eric, and that's for our residents to get involved. Yeah. So thank you again. Hey, students, you can leave or you can leave now. This meeting's adjourned.
you can take a cookie with you too.
Yeah, please. That's really gonna affect the office staff if you don't grab a treat.
Yeah. I'll still be around.
Oh, you'll be the best.
That's not good.
No, I
Expect to see you at public hearings.
I may occasionally show up. You never know. If I'm,
City council meeting.
no, well, I was in Oklahoma.
Dude, we could.
Oh, I'm sure. I'm sure. No, I was in Oklahoma. Actually,